first of all, thank you for letting us be a part of this presentation and give some information out to the members, the new members and the old timers that are out there. We're very blessed to be a part of the organization and do everything we can to help the investor community out there. The second thing I'd want to say, of course, is today is St. Patrick's Day. So I hope I'm not wearing green because I don't have a green shirt that goes with this jacket, but happy St. Patrick's Day to everybody. I hope you celebrate a little bit tonight and have some green beer or something like that. Today's topic is about creating a legacy, how to create a legacy, and the law firm's role in that, as well as giving you some guidance on it. I'm going to cover a number of subjects and just kind of hit them in sequence. I'll tell you what they are just so you've got your thoughts in line. And if you have questions, feel free to ask them. I will kind of stop at every section and just kind of take questions. So that might be the most efficient way to do it. And, maybe just kind of be following along. So my first topic is going to be doing it right from the beginning, right? So if you're taking notes, do it right from the beginning. The next section I'm going to talk about is asset protection. And this is some of the LLC things that Todd was talking about a minute ago, but there's other issues as well that I'm going to talk about in detail. The third topic will be estate planning and just kind of getting into some of that a little bit and why it's important to your legacy and how to do it right, how to manage it correctly. The next topic is kind of a generic one where I say, let's describe how to work with an attorney. And we get beginner clients and we get intermediate clients and we get folks that have been in the investment business for decades. And I think it's helpful to know the best way to work with us so that you get the most bang for your buck. And so it's efficient and we don't get frustrated and you don't get frustrated with well, if I talk real fast, it's going to be less expensive for me and stuff like that. So I want to talk about how do you work with a lawyer, and I think all lawyers would agree with what most of the things I'm going to talk about. And the last thing is kind of the philosophical part of the discussion, and that's working with your family. And that's part of the legacy issue, right? So I want to dive into that a little bit because your family may or may not be part of your business right now. And I want to give you some personal experience, some guidance, and some thoughts about what's it like to work with your family, how to do it the best so that you can leave a legacy for them. And I think our legacy is not just the money part, but it's the business itself, the stability it provides for your family, all the many benefits that we have from owning a business, whether it's a law firm or real estate company. It's all the same thing. We want to provide and protect our families and see that something of our dreams and goals going forward. So those are my topics for the day. I'm going to start back at the beginning, doing it right from the beginning. This is very key, right? So if you're going to do something, I really think do it right. Don't take any shortcuts because in business and in investing, particular and in real estate, there are no shortcuts, definitely. There's a lot of money involved here, whether you're just flipping a property and wholesaling it or whatever. There's a ton of money involved, and you can't underestimate the importance of, when there's dollars involved, people get squirmy. And in order to protect your family and to leave your legacy, you've got to be careful with it. You're investing your valuable time. You're investing your valuable equity that you've worked hard to save up. You're maybe borrowing a lot of money from a lender or an investor that's a partner with you. So I'm going to talk about a call I had earlier today with a client or a prospective client, and he was doing a deal, and he brought in an investor on it, and there was another party that was going to do the debt part of the debt piece, and things have started to go sideways on him. and it's making him very uncomfortable, which of course it should. It's just the fact of the case. So you've got to really be careful from the beginning of a deal, and from the beginning of your business. So be very, very careful. And the old saying that an ounce of prevention is worth a pound of cure is absolutely true in your real estate investing business. And if you don't do that, you're gonna create losses going forward. This is a long-term business, and there's going to be changes over time. So you have to be managing things from the beginning carefully and prudently, or it's going to go bad. One of my mentors, and maybe this is a common truism that you might have heard from other people in the business, but you want to avoid losses, right? You're going to make money on the deals that you walk away from. That's part of what we're going to talk about next in asset protection. But you got to be careful to walk away from deals. Every deal is not a good deal, and you don't want to put a square peg in a round hole and try to do something that's really not working. If you do, it's going to go bad, and it's going to create a problem. And I see this with investors, particularly investors who are newer or that are undercapitalized in the business. And so they're trying to get a foothold. And certainly you can do that in the business without a lot of money. You can get involved in real estate by brokering or bird dogging or wholesaling or whatever. There's lots of different things you can do. But when you're doing that, you avoid the temptation to try to force something through, and look at a deal from the beginning and make certain that you're going into it the correct way, that you're going to walk away if you need to, because the other side is not always reputable, not always honest. If you're working on a transaction where you've got a quote unquote motivated seller, think about that. The motivated seller is somebody who's got problems. And if they've got problems, they may underestimate or not tell you everything that's going on in their life or everything that's going on with the property. You're a white knight that's there to try to save them from themselves and them problems. And it doesn't always work. So you got to be really careful that you can walk away when needed and avoid your losses. So this is long-term. This is a long-term business. It's not a quick business. You can make a lot of money quickly on a transaction, but normally there's a lot of work that goes into it from the beginning, and a lot of hustling, right? You got to really knock on a lot of doors before you find a transaction that's going to work for you. You've got to evaluate lots of deals. This is true no matter what level you're on. We work with a client out of Kansas, the state of Kansas, and he's a professional syndicator, and he syndicates $8-10 million commercial deals all the time, constantly. And they look at over 100 deals per day, over 100 deals per day. And then they winnow it down to a very small number that they look into a little bit deeper, and then a very small, tiny fraction they actually make offers on, and then actually go under contract and close on. So don't think that you're special or that things are tougher on you or whatever. These are in the professional investment business, you are looking at hundreds of transactions to find good ones, and just be careful with that. So do it right from the beginning. Don't cut corners. If you try to cut corners, it's going to bite you eventually. It will bite you, and you just got to be careful. So let me take a break there for a second, Angela, and take any questions. I don't have the chat open on my screen. If you're getting questions by chat, please repeat them to me, but I'll open it up for any questions kind of at the beginning there.
So I will say there are no questions in the chat. And so if anybody does have any questions, just go ahead and unmute and ask it directly.
Yeah, that'd be good. Hearing none, I will just continue forward, but thank you. So we'll do the same thing as we go through every part of the presentation. The next level of leaving a legacy for your family is asset protection. And this is kind of going back to the idea a minute ago that you make money on deals you walk away from, and you need to avoid losses. You can, I'll tell a story, and I've told a number of clients a similar one. A client came in, a prospect that knew better but didn't handle things correctly in his asset protection, and he didn't have an LLC on one of these projects, and it went bad, and he was ending up basically losing everything. Insurance wasn't going to cover it, and he was a seasoned investor with decades of experience and 7 figures of net worth, and he was trying to figure out, is it too late to move my money offshore? Answer, yes. You really made a mistake here. So you got to avoid losses, and you got to do your asset protection correctly. And my first point on this is that you need to do, you need this before you even have anything to protect, right? Once the lawsuit comes up, it's too late. Once the transaction goes bad, it's too late. So you think that you're starting into this asset protection idea and using LLCs and whatnot, and due diligence in the transaction that we're going to talk about some more too. But you have to do it before you really think you've even got anything to lose, because by the time you build it up as you go along, or if you get into a deal that goes sideways, then it's too late at that point to try to put the toothpaste back in the tube. You really have to address these problems from the beginning and protect yourself. It's just like if buying homeowners insurance for your house and then having a house fire. If you don't have the insurance up front, then it's too late once the house is burning. It's too late to call your agent and get your protection. So you got to do it up front, and always up front. It's less expensive than the problem that's created down the road. So even though you spend a little bit of money doing a little asset protection, it's always, again, an ounce of prevention is worth a pound of cure. It's a truism, absolutely. So do this before you've got a lot to protect. If you've been going along and you've got a bunch of properties and you've never put them in an LLC because you were too lazy or just weren't being diligent about it, or whatever, you didn't know a good resource to go to and how to structure it, you started to get embarrassed, like this client that came to me and had the property, and it was a fire. Somebody got the boyfriend got angry and tried to burn down a building, and everybody started jumping out the windows, and this tenant became a quadriplegic and had a small daughter to take care of, so it was a nightmare. Anyway, you've got a lot to protect, and you need to get into it early. Number two, the second point I want to make to you is you got to use your LLC. You absolutely must do it. We're going to talk about that some more in this section. It's so easy to create an LLC. It's so easy to set up the documentation, but you have to do it right, and you have to manage it correctly, right? This is part of every deal. And we always are recommending that you, with your LLCs, I'm going to stay with that for a second, that you use a new LLC for every transaction. And the reason is that if the deal goes bad in the closing phase or in the transactional phase before you become the owner, and you need to walk away and get out of that deal, or there's litigation where they're trying to force you to close, or they're suing you for breach of contract, and there's some major problem, you want that LLC to be empty. You want it to have no other assets, no other operations, no other nothing. So that if there is litigation, and there frequently is, right, when there's a lot of money at stake, that's where we started, you got to realize that if the entity is isolated, then all your other business operations, all your other rental properties, all your other construction work and rehabs and whatnot, those are not being affected by this litigation on this one property that you were looking at going under contract for. And so your financing on other properties won't get ruined. Or if there was a mechanics lien on this one property that we're talking about, it's not going to ruin and poison these other properties. So be very careful with that. That's why we do it. And these deals do go bad, and people need to bring litigation. for various reasons, seasoned people and beginners, it doesn't matter. Mistakes happen. So you really do need to have that purchase agreement even in the name of that new LLC. Try not to put it in your name. And I'm picking on Todd Atkinson because we had a discussion a minute before, and I know he's on the line, but Todd, don't do the purchase agreement in your individual name and say and or assigns, right? That's better than nothing, but you really want the purchase agreement in the name of the LLC. So create it up front, do the purchase agreement in the name of the LLC, and then all the problems that might come up are isolated and siloed over into that LLC. Very important. So I want to talk about that. The next thing in the discussion that I want to mention is the idea of your due diligence and your documentation, right? Asset protection is not just the LLC itself. It's the documentation and the due diligence throughout the process. Today, we had a client call in, a prospect, and I just use it because this is what comes up every day, right? They bought a property, they relied on the seller's representation about the condition of the property, that it was a buildable lot, right? So this client is an investor, he's gonna buy a lot and he's gonna build a spec home on it and sell it for a profit, right? Great business plan. Experienced realtor, experienced investor, but he bought this property and relied on the documents that were in the MyBor system, right? So the seller had a listing and said, this lot is buildable, hurry and buy it. It's ready to go, etc. And they even had some, I'm going to call them engineering documents that attested to the fact that the property was buildable. And so they bought it and closed, and they hadn't gone through the whole building process. And it turned out that this was on a well and septic. And so the septic company came out and said, well, I don't know what this engineer said, but the lot is not viable for the septic system. It's not buildable. And so this is a typical example of kind of glossing over your due diligence and then buying a lot that now you can't build on. And so we're trying to figure out, and I gave them 2 or 3 alternatives of what to do with that. But it points out that in your purchase agreement, it's the 4 main contingencies: title, survey, inspection, and financing. And the inspection would have been the part where the buyer had built-in contingencies about whether the lot was buildable or not, what they were going to do, the testing they were going to do. And the buyer needs to do their own due diligence. Never rely on what the seller provides. The seller in this case was not dishonest. They just made a mistake or made a possible mistake. We're not sure yet. But the seller is just saying, here's my property, buy it if you want to, do whatever you want. A buyer is incumbent upon them to do their own due diligence, hire their own experts, right? So in this case, my first question was, who hired the engineer? If it was the buyer, now you've got a cause of action directly against the engineer because you were in privity of contract with that engineer, and you can go back to them and say, wait a minute, you committed malpractice, you broke this contract, you were negligent. There's 3 legal theories: contract, professional liability, and negligence. Those are all bases to go back against them. But since the engineer's contract was with the seller, the buyer's in a more difficult position, and their remedies are more tenuous, more difficult to acquire. So you really have to be careful, and that's where your legal counsel ought to be guiding you. We were not involved in this transaction until after the fact, and that's part of what we'll talk about later too. Is that your legal counsel would be the one that helps give you objective advice and helps you make certain that you're doing the transaction correctly and you're digging in through all the layers that are necessary. So be very careful. You got to have these contingencies in your deal. You have to get out before you close. You have to walk away on that last day, or you must get an extension of your contract. Do not do not fall into this trap that you're working with friends or they're good guys. You know, they're experienced. We're all, you know, working together. All of our interests are aligned. We just want to get to the closing table. No, this is all black and white on the documentation. You must be careful with it. So be very careful with this. This is where your lawyer is an objective provider of independent advice. A broker or somebody else is in the deal to make money, and you're in the deal to make money. So your vision is clouded by your self-interest and your hopes and dreams for the you know, for the project and your vision. I don't say hopes and dreams in a negative way. It's your vision, right? You've found a site. You know you're going to do something there. It's part of your plan. It's fitting good, right? That's just you're sort of blinded by that. Your objective advice to protect you from losses is your independent counsel. Your real estate broker does function in this way in a lot of capacities, but they are not necessarily looking at it in the same way that a lawyer is. The realtor is looking at it also as a commission. So they're incentivized to get you to the closing table, rather than, you know, a lawyer is not a deal breaker, but we're a deal maker to be certain that it is a deal that you want to make. It's not, you know, it's not something you have to do. So you got to be careful. Be very careful. Next, I want to talk about just for a minute about rehabbing, because we got a lot of rehabbers in Syria. There are many, many pitfalls in rehabbing, and your legacy for your family and for your business can be ruined in one deal. We have lots of situations where experienced rehabbers contact us and they say, they start out the conversation this way: I should have known better, right? They knew that they were doing was you know, putting them at risk, but they, by experience or by the momentum of the transaction, they were you know, kind of not forced into it, but they just, it was hard to stop themselves, right? Again, due diligence. So we see a lot of six-figure rehabbing deals go bad. Six figures meaning 100,000 and more. They go bad because there may be a pattern of using the same contractor where you have experience and you've got a relationship and everything is going okay. However, contractors are human as well. They make mistakes. They get too busy and they get shorthanded, or they get caught in a jam between your project and two or three others that may be going on at the same time. And so the money doesn't flow well and your project gets delayed or it's not being done. So I'm going to say on your rehabbing projects, you must inspect on not a daily basis, but before you give payment on a draw, you need to inspect the work visually, personally, or have a representative do it that's not the contractor. You must. When we're doing commercial construction projects and litigation, there's always what they call an owner's architect and contractors meeting once a month to walk the property and make sure it's being done correctly. These are sophisticated multi-million-dollar projects, and if they require that level of supervision and you know, not justification, but that they're going back and verifying that the work is being done with highly professional people, the smallest deal needs the same thing. You need to look at the deal. You need to walk your property. You need to see it and make certain that the work is being done, because in too many cases, the work is literally not being done. And you get six figures deep and you've written checks and you trusted them, and suddenly now you've got a major problem. So rehabbing, don't think that you're immune from this. This is asset protection. You must verify that the work is being done before you cut checks. Banks do it, even with the best of the best contractors. That means we ought to do it, even if you're the smallest of the small contractors. Verify the work. I'll give you one personal story that you may have heard me tell, because it's embarrassing for me. But one of the first property I ever bought was with me and another lawyer. We did a drive-by and we bought it, and we were going to rehab it and flip it, and we didn't walk the property. Guess what? It was a burnout. The whole house was completely burned out on the inside. And so we had just bought this house that looked perfect from the outside, and it was completely burned out on the inside. And we were in a huge mess. So we ended up wholesaling it to somebody that knew better. That was our first deal like 100 years ago. And so it happens to everybody, right? You got to walk these properties. You must, right? And if I knew now what I knew then, I would have never bought that property, or I'd paid a fraction of what I did. We got out of it. We made money, but it was a mess. So I want to just talk about those couple things. So I do want to talk about two things on your LLCs, right? So we do a couple different ways we do that for your asset protection, and then passing that down to your heirs, which is part of this legacy talk. And I'm going to go into estate planning next, and how to use your LLCs and transfer them very quickly and easily through transfer on death designations. I want to deal with that. We have our own, a discounted version of LLCs for CYREA members, $9.95. You can get it. You can get that flyer from our table every month when you're at the main meeting. We also have created an LLC kit that's got 4 or 5 hours of education on it, on a video series, and then all the forms and templates. So if you're a do-it-yourself type of person, we've been selling this kit, and it goes through all the aspects of an LLC and why you need it, and how to protect yourself, and how to avoid piercing the corporate veil, and all the different things that I deal with on a daily basis. It's like 5 hours, 4 to 5 hours of literally point by point by point explaining what the law is and showing you how to create your own LLCs, giving you the form templates to do it, and going through the highlighted part of those documents so you can do it yourself. If you want to do that, it's going to be in the materials that Angie provides afterwards, but the website is like M-Y, DIY, as like do it yourself, realestate.com, DIYrealestate.com. And then if you put in /partner/CYREA, you get a discounted price. It's normally $9.95. It's only $5.95. And we have a partnership with CYREA on that. So if you're a do-it-yourself, or you just want lots of education, that will help you run your LLC better and help you manage things better as you go forward. So I'm going to stop there before I get into estate planning for a few minutes and some of these other areas, and see if you got any questions that I need to deal with, Angela.
Okay. Okay, so Larry and Deb just said that they got a lot of benefits from the video DIY LLC that you were just talking about. I also put links in the chat to everybody. So if you want to check out the My DIY webpage, it's in there. Jeff also did a video back in January, basically explaining that. So if you just want more information about that and you want to watch the video before diving into the course, that link is also in the chat, and I will include these in the email as well.
Okay.
No questions in the chat, just Larry and Deb's little comment about how awesome the DIY program was.
Thank you.
So if there are any questions, go ahead and just unmute and ask away.
So this is Todd again. I have a general one. So I want to talk about recourse. So specifically with rehab, if you have work that a contractor is going to do, that's documented, you have a documented SOW, and you find that for some reason that work wasn't done correctly. So my question is, what is the statute of limitations around going back for recourse in that event? And is there any recommended documentation, or would you advise us investors to keep on hand for documentation and proof?
Great question. Thanks, Todd. So there's different statutes of limitations depending on the type of cause of action. A contract claim is 6 years. So if you sue only on the contract claim, that's 6 years. 6 years. If you're suing on a fraud, right, there's a 6 year. If you're suing under negligence, that's 2 years. So there's multiple different statutes that apply depending on the situation. So 2 years or 6 years is really where you're going. As far as your documentation, I would pray that you put in an attorney fee provision if there's a breach. I see lots and lots and lots of scope of works from contracts that are in place and they have no attorney fee provision. And that can be a powerful incentive to settle a case if you're getting attorney fees if the other side breaches. So you ought to have a sentence in there, and I'll try to provide something for Angela. I'll send you an email to put into or I'll put it in the materials. I'll add that. An attorney fee provision, but almost anything will work, right? Just like you have in your lease, if it says, the party enforcing this is entitled to attorney fees in the event of a breach or default. So something like that. So I'll give you some language, but almost anything will help you. That'd be the most important. The next thing for recourse would be your documentation, photographs, and also expert witness. Those are your next two things. So you want to document things, which is why I'm encouraging you to do walkthroughs periodically through the rehab process so that you can document the condition at the time and that everything is okay, or when it goes bad. So those are a couple ideas. Does that address your concern, Todd?
It does, thank you. And I guess, to add to that, when you go after recourse, is it typically if you have an event that happens, let's say like a basic electrical repair is supposed to be done, it wasn't done correctly. I mean, is it usually when an event happens and there's damage, and that's when you go for recourse? Because trying to get somebody to do an electrical repair, maybe a minimal thing. So I'm just thinking what that cost benefit may be. Is it usually if there's an event you would go after recourse? There's small things that may not be done correctly. Is it worth going after?
Yeah, good question. Cost benefit is definitely part of it, including the attorney fee part, which is why I recommend you make certain you've got that in your all your contracts on these scope of works. I think the next thing to give you some strength in your documentation is to be as detailed as possible with your scope of work. So the contractor can't say, well, I used my own discretion in this. You didn't ask me to do that. I fulfilled my contract because I did, this minimal thing. It just said, electrical work or, electrical box or, whatever it was, some small description. You need to describe it as detailed as possible so that you've got the most ways to go back. Small repairs, little thing, are not worth the litigation, but it is worth, sometimes it's in small claims court, it's worthwhile, but usually it's not. So you got to be, use a licensed contractor, make certain that they've got proper documentation so that they are qualified to do the work. And another little trick that we found is that a lot of general contractors at least have licenses on file with the state, and they have a bond, and they have, usually it's small, but 10,000 or whatever. And you can, if the contractor's bonded, then you can apply to the city and file a claim on that bond. And it can be a very quick way to recover against them for smaller amounts, and can really also then put them under pressure with the city to take care of those things before they're allowed to be, doing any more contracting work in the future. So that's a powerful little remedy that can help out.
Great, thank you.
Yep. Okay, let me move on for a minute to estate planning, and some of this can connect the LLC with your estate plan. So I've done hundreds and hundreds of estate plans for clients. Some of them very simple, some of them complex. But the key thing about an estate plan is to realize that it's important, no matter what level you're at, to make some arrangements in case you pass away, right? We all are going to pass away someday, or we're all going to get disabled from an illness at some point. And we need our business to be able to continue. That's what estate planning is about. Take care of you while you're alive and well. and then take care of your family members and loved ones after you've passed away. So the biggest problem we see is that people don't do planning at all, or they've done very inadequate planning many years ago, and it doesn't take into account the work that they're doing now in their new business and their new ventures and whatnot. And truly, lawyers love probate court because it's kind of a gold mine for us. I hate to say it that way, but it's a great business because it's very time consuming and it's costly, and you have to do it unless you prepare correctly. Probate is 100% avoidable, and you can manage your affairs in a way that doesn't require more than a very few phone calls and a little bit of transfer work on our part to get your affairs moved forward to the next level. But many people don't do those very basic things, and they end up losing so much money and so much time and frustration going forward, even with family members who predecease you, right? So we see a number of times where you may have, we'll say it's your parents, coming down to our level, right? And you may have a sibling, a brother or sister who has passed away beforehand, and your parents never updated the estate plan to cover that contingency. And so now you might have the grandkids involved in the estate plan that you didn't want. They might be minors. That's a huge problem for operating a business with a minor. You just can't do it. And so guardianships need to get involved, and all these other, unintended consequences happen when you don't keep your plan updated. And when I say updated, I'm not talking about every year. I'm talking every, maybe 5 years, at least think about it. So your estate plan is a huge part of your legacy. One of the things that we do with LLCs when I'm having an interview with a client is I always say, well, who do you want this LLC to go to if you die? Because there's a statute that's called a transfer on death, and it allows us to transfer property, whether it's real estate, stocks and bonds, anything like that, to another person immediately without probate after you die. And that saves tons of time, and it makes it very efficient for your heirs to take over your business from you and your family members. So a transfer on death provision, we almost always include it on our LLCs, or we at least talk about it and decide, no, there's no reason to do that now. I'm going to handle it in my estate plan. I'm going to use my trust or my will to handle this part of the transfer. I don't want to put it into the documents themselves. But a TOD, transfer on death, can be used for real estate, for deeds, and it can also be used within the LLC. So we had a question before we started the meeting today about transferring your real estate into an LLC and what's required. And we would just use a typical quitclaim deed, but we use some special language in that deed, and it would go into the LLC. And then your LLC would transfer that ownership by TOD, transfer on death, to whoever you wanted it to go to, spouse or whatever. Or it could just be my estate, or it could be my trust, right? TOD to my trust. That would also be okay. Or leave it in the trust to begin with. I covered a million different options. Anyway, you have to look at your business and say, how is this going to go after I pass away? And I want to set it up so that it's very simple for my family members. Imagine, if you could, the complexity if your brother or your sister were to pass away and you were called upon to try to arrange their affairs. And they, like my sister, she lives in New Hampshire, 1,000 miles away. I barely know her address, right? So I've got to go to New Hampshire, try to rummage through her house, figure out where she kept her private papers, figure out her banking, figure out her assets, figure out her liabilities and all these different things, and then coordinate it, notify the court, explain it, categorize it, get her heirs to consent to what I'm doing, right? She has 2 boys. So, it's just a nightmare. So, and especially when you're trying to do that for someone who, our own affairs are complicated enough. Now try to do it for somebody else. That's why you need these estate plans in advance, so that everything is very clearly spelled out and organized. And we often do client meetings for the family after the fact. So we'll do, I call it mom and dad's will or mom and dad's trust. And then we notify the family members with the parents' permission, here are the documents. We want you to know what's happening in case something happens to mom and dad, so that they're aware of what's going on and somebody can kind of pick up the ball and move forward a little bit easier. This is also true when there are multiple estate plans. So people have maybe kept old documents, and there becomes a dispute over which set of documents are the ones being used in the estate. So we tear those old ones up, fresh documents going forward, and we know that, and we keep records of it. So you got to be very careful. If you have partners in your business, let's talk about that. You always need to figure out a way to buy them out at death, or if there's a disagreement. So that's part of your estate planning and your legacy planning, is what do I do with these partners? Because they may not want to be partners with the rest of your family, right? So how are we going to get them out? A lot of times you can use life insurance as a tool for that purpose, but you at least need to think about, how do we get my partner out? And it could be a buyout, like on a land contract or an installment contract. I've seen some of the biggest real estate investors in the business in our city. I'm very familiar with one in particular. They were strip mall developers, and one partner died, and the surviving partner bought out the wife with a long-term installment contract, and that was perfectly fine. But you got to have an idea of what you're going to do, how you're going to do it, how you're going to value it, what's the methodology, et cetera. So you got to be very careful with that. So I sometimes tell people, I want to move down my notes here, fair doesn't always mean equal. And this is true among your children, that you want to treat them fairly, but it doesn't always mean equal, because they have different needs and they have different abilities. So you may decide to provide for different children differently, and you want to be careful with that. And that's part of that's the counseling role that a law firm has in helping you work through that. And since we've done it hundreds of times, we're not having that conversation with you for the first time. This is something we've dealt with, and we can give you examples of other families and how they've done it, not disclosing something confidential, of course, but saying, well, here's your alternatives. And then it's up to you to decide, well, from here to here, this is what I'm going to do. These are my different options. So consider that. So your estate plan is a big part of your legacy and your family planning. Again, it doesn't have to be expensive. You got your basic documents, a will, a trust might be involved, healthcare power of attorney, general power of attorney, and living will. Those are your 4 main documents or 5 main documents on every plan. And there's a set series of questions that we would go through with everybody to decide, what do we do? How are we going to manage this going forward? And again, our role is counseling to give you options so that your business can then continue forward. So it's not expensive to do up front, even if you're spending a little bit of money, just like you do on your LLC plans and stuff like that. But let me promise you, if you don't do the plan, it's going to be a nightmare emotionally, B, a nightmare transactionally for your family members and loved ones, and C, it's going to be expensive, because it's very costly to try to figure everybody else's affairs out and manage them through the court with the court supervision when you don't need to. Totally avoidable. The only winner here is the law firm, right? So I say that as a joke, really, but it's terrible. I see these problems that come up with people, and there was a question earlier about like a statute of limitations, but people might say, oh, I've got a will. It says I get the house or I get the business, but they don't probate it, and they don't go through the legal process of getting legal title in their name. And then 5 years later, it's too late. You've gone past the statute of limitations. You got all these different problems in an estate that if you don't solve them within the first year or two, you've created a bigger mess, right? So don't think just because you saw a will and it said you get it, or you're giving it to your spouse, that there's nothing further to do. That's the absolute wrong way to approach it. You must take that will at the moment of death, contact the law firm and say, what do we do next to get all this implemented correctly, just following what's written in the will or the trust. And if you don't do that, then you really have created a giant mess that, again, the law firm loves, but it's a mess for you, right? So let's talk about, that's all I want to say about that. Finally, or the next two things I'm going to cover very quickly, working with an attorney and working with your family. The best thing that you can do when you're working with an attorney is be prepared for your first meeting. Know who's involved, who the parties are on the left and the right. I'm not going to take questions till the end because I'm going to try to move through the material real quick here for a second. So I'm going to stay on working with your attorney, Angela. So be prepared. That's number one. Know who's involved. That's number two. Number three, have questions ready, because when your lawyer is going to have a lot of questions, but the more you are asking, that means you're better prepared and you'll have a better utilization of the law firm and their skills and resources. Also know your goals. You know, what's the end game that you're trying to accomplish with the representation and the problem. And maybe you're not quite sure. Like the guy this morning, he was like, I don't know what to do next. I've got this problem with the property, the engineer, you know, what can I do? I gave him 3 solutions. I said, go try this. And if it doesn't work, come back. Or if I need to get involved, come back and talk to us. And, but so there might be just an assessment that you don't know what to do, and that's okay. But to the extent you've got some goals in mind, that's also very helpful. I also want to emphasize that lawyers work on documents. So whatever it is, we're constantly asking clients for copies of documents, correspondence and whatnot. And it's very important to get those things organized. If you're unorganized and have a hard time pulling your facts together and your supporting information, then it makes our job very difficult. Difficult means expensive. It also means that your outcome is uncertain. And when the outcome is uncertain, you're either going to get less money than you're deserving, or you're going to pay more than you would have to if you were more organized. So documentation, that's how we work. The last thing I tell you, something I tell all the members of the law firm, is that realize that when you're in litigation, you're trying to force somebody to do something they don't want to do. So the friendly relationship is out the door, and now law firms are involved probably on both sides, and both sides are forcing each other to do something they don't want to do. That's why it's so difficult. That's why it's so emotional. That's why it's so frustrating. And your intentions at the beginning of the deal or whatever it happened are so problematic because we're forcing somebody. And the courts don't want to force people to do something either. They want you to work it out. They're always trying to force us to work it out. So just remember that. That's why it's so problematic in working with these cases. So those are some key points, I think, for working with the lawyer. And the more specific the engagement, the easier it is for us to deal with and give you advice on. The last thing I want to talk about on legacy, and I'm just going to spend 5 minutes on it, is working with your family. Many of you know that our family is all involved in the law firm. My wife works with me, and she's the operations manager and does quite a bit for the law firm. And my son, Tim, is involved in the business as well. And our daughter, Kelly, is also involved as a marketing director. And that's grown over the years, right? It didn't start out like that. It started out just me hanging out a shingle years ago, 27 years ago, right? But a lot of people say they don't want to work with their family, or they can't work with them, or it's a disaster, whatever. I take the exact opposite approach. And I think that's especially important in your real estate business, because you're wanting to leave a legacy. So you're wanting to leave this for your family, and so you might as well involve them from the beginning, or at least at some point and in some way. At the minimum, bring your spouse in or your loved ones in as advisors. And you have like a board meeting for your LLC. You need it for the formalities of the company anyway. Get some independent advice from your family members on critical things and talk through the business with them about what's going on. Everybody in the family brings something different. And when my wife Gina and I started working together, we really butted heads on a lot of things because we both were trying to do the same thing. When we separated her role and my role, it just was like a key in a lock turning it open. And the business, began to flourish like nobody's business. And it's because I have certain skills and things I'm great at, and Gina has things that she's amazing at. Same thing with Tim. He's amazing at certain aspects of the business that I am terrible at. And Kelly, the same way. Everybody and all our lawyers, right? The other lawyers that work for the firm, we've hired them intentionally based on their type of personality and what they are best at. And our family then has a little bit more of continuity running the business. So if I died or somebody else would have a tragedy, then it's a little bit easier to keep the thing going, and the legacy of the business and the legacy of the law firm continues. So it's very important to most people when they start a business. I've never met a business owner that wasn't happy about, their sort of their life's work, right? It's not just a job, it's sort of their life's work. And they want their family to benefit from it and be protected by it and have it be an ongoing thing. And it's joyous to work with your family and to joke around and everybody to be involved in things. It's wonderful. So I take the position as a legacy, as a business owner and dealing with real estate constantly, that working with your family is just fantastic. So I would encourage you to do that rather than them find out on your deathbed with your will or no will what was going on, right? Bring them in now and have a great time. Enjoy the legacy while you're alive as well as afterwards. That's all I've got. I'm gonna stop for now. If there's questions, I'll take whatever we can. Thank you.
Well, the only comment in the chat is that it seems like we have a member back when you were talking about going through probate, and he was basically like, yeah, this is exactly what is happening with my brother who passed away.
I'm sorry.
About a year ago.
I'm so sorry.
Yeah, so.
I hate being right. So it's a tragedy, and it's just a lot, right? So many things can be avoided through just some basic estate planning. It's not tricky and magical. Do not be afraid. It's like going to, the doctor or whatever. Don't be afraid to go to your doctor. They're there to help you and heal you and make your health better and give you ideas or whatever. So, do not be afraid. Again, working with a lawyer, that it's going to be scary and intimidating. It's not. I'm not scary and intimidating at all. I like to just be open and friendly and helpful. And we always do our consultations free, right? So we have a phone consult. Find out for free, spend 30 minutes, and there's no cost for that. There's no obligation. You can take my advice like I gave this morning to this guy. He might take that advice and hire somebody else. I'm just we want to help and serve our investor clients in any way we can. And there's no cost or obligation up front. Thank you. Other questions, Angela?
Not in the chat. We have 5 minutes left, so I will just leave it open to anybody that wants to unmute and pop in.
Dive in. Yeah, thanks.
Hey, Jeff. This is Will Smith. So I haven't done any sort of deals. We haven't done anything real estate related. I don't have a will, but my brother was the one who died last year.
Okay.
So my other brother has been really tied up with that. So how does all of that work? Like, I intend to start with wholesaling, and I'm working on getting marketing together and doing all this sort of thing, but nothing has happened yet. So at what point do you start creating LLCs and I mean, do you need that for wholesale deals? I intend to expand.
Yeah, of course.
Sorry.
So it's a good question, Will, and I'm sorry about your brother passing. That's horrifying. I wasn't trying to,
No, it's totally true.
It's just, it happens. It's every day.
It's totally true.
So first of all, I'm going to say estate planning and LLC. The estate plan you ought to start on today, no matter what, because nobody has a guarantee for tomorrow, and we don't know what we're going to have. You might be in the middle of a deal that has tremendous value for your family as a wholesaling deal or something else, or have several in the pipeline, and you'd want to be able to have those continue forward. So starting with a business structure and incorporating that into your will, like I said, an LLC with transfer on death provision going to someone so they could pick up the ball and move forward instantly if there was a tragedy, that'd be number one. The LLC, I want to echo the comments I was trying to make earlier, that do get an LLC before you do anything else, because you want to go into the transaction in the name of the LLC in case it goes bad and there's litigation, or it doesn't necessarily go bad, but it's just you need to get out of it and you want to walk away and not have any repercussions. So that, that if the seller that you're trying to contract with has something crazy, you don't want to be tied into that personally. So you want to have that LLC up front, and then you can walk away from that deal or let the litigation play out, whatever it is, or the dispute for however it goes, or just ignore it and say, my LLC, go knock yourself out. Have it isolated that way. So I really encourage people to do that. This is a lesson I didn't learn immediately, but I learned over the years. And I saw some of my most sophisticated clients buying things or creating LLCs before they even went under contract with an LOI, a letter of intent. And I was like, man, that seems pretty conservative, but over the years, I've seen it go bad so many times that I'm really, became a believer of the necessity of creating that LLC up front. So never too early.
Thank you. Yeah, that's extremely helpful.
Yeah, thank you.
Gosh, Jeff, this information has been so informative and you sound so knowledgeable. How in the world can I get in contact with you for all of my legal needs?
Oh my gosh. See, that's where your family always has your back. Thank you, Tim. Right. So if you need to contact us, try the phone 317-810-1400. And Kelly will pick up the phone and set an appointment for you. Otherwise, you can also get on our website and look at the things that we do. www. and then it's my name, jeffjinkslaw.com. You can send me an email, attorney@jeffjinkslaw.com as well. So thank you. Thanks, Tim.
Hey, I was going to put all that into the chat. What was your phone number again? Can you just repeat it so I make sure I'm not transposing anything?
Correct. Yeah, the phone number, area code 317-810-1400.
Okay.
And that's good. I guess I might mention as well, while we're doing some of that, our law firm is located in Carmel, but we represent people statewide. We also have an office in Florida, which is where I'm at right now. I'm in the Florida office doing business down here. And so we can handle cases in Florida and property transactions. And we found that we did that because a lot of our clients up north vacation in Florida, and they own investment properties in Florida, or they're doing deals in Florida. So we're licensed there as well as Colorado. So we're in 3 different states right now and can really provide guidance in any of those places. But just call the main number, the 810-1400 number, and we'll set it up.
All right. Well, it is 1 o'clock on the dot. Last call for questions. If nothing else, I put Jeff's contact information in the chat so you guys know how to get a hold of him. Otherwise, I guess we could call it a day.
Excellent. Happy St. Patrick's Day to everybody. Thank you for joining the call. Thanks for the questions. And Angela, thanks for being our host. Yeah, no, thank you for hosting. I really appreciate it. Have a great day, everyone.
Bye.